Hey everyone, welcome back to the channel where we break down complex legal topics to help you navigate the legal landscape with ease. Today, we are diving into an important topic for anyone considering buying a franchise. The top 5 considerations and contractual clauses a franchisee should review in a typical franchise agreement. Now, franchise agreements are the backbone of the franchisor-franchisee relationship. Because they contain the terms and conditions under which a franchisee operates a franchise. Understanding these terms is crucial for a successful franchise business. Here are the top 5 considerations and contract clauses you should pay close attention to. First up, let's talk about initial fees and ongoing costs. This will include the initial franchise fee you pay at the start of the franchise, which is usually a lump sum. It could be 50,000, 100,000, $500,000. You also need to consider ongoing costs like royalty fees, marketing fees, and other operating expenses. Ensure you understand what these fees cover and how they impact your bottom line. Ask yourself, are these fees reasonable given the support and benefits provided by the franchisor? The truth of the matter is that most franchisors are greedy and will want you to pay multiple types of never-ending fees. So do your calculations, do your due diligence, check the franchise agreement to make sure what fees you are paying. Next, let's move on to territorial rights. This clause defines the geographical area where you can operate your franchise without competition from other franchisees of the same brand. Master franchisees usually get the whole country, and then they would have sub-franchisees who receive territorial rights within a state or within a city or specific part of the city. It is important to understand your territory rights to avoid conflicts and to ensure you have a sufficient market to operate profitably. You should clarify whether your territory is exclusive, that means all for you, and you should also clarify the conditions under which the exclusivity can change. For example, the franchise agreement may state that you no longer have exclusive rights to this area if your sales fall below $1 million. Look out for clauses like that. Another key consideration is training and support. A good franchisor will offer comprehensive training programs and ongoing support to help you succeed in your franchise. This would include initial training, marketing support, operational guidance, and access to proprietary systems. Review this clause to understand what kind of support you receive and for how long. Ask the franchisor for specifics on the training duration, content, and support channels. It is common to see clauses requiring the owner or senior manager to attend annual training or refresher courses. And of course, who pays the fees and the airfare for such refresher courses? I'll leave it to you to answer that question. Now let's look at renewal and termination clauses. These clauses outline the terms for renewing your franchise agreement and the conditions under which either party can terminate the franchise agreement. Pay attention to the renewal process, the fees involved in the renewal process, and any performance criteria or hurdles or targets you need to meet. For termination, understand the grounds for termination and the notice period. I have sad news for you franchisees out there. Usually in most franchise agreements, the franchisor, the person who franchises the franchise to you, has the right to terminate for virtually any reason. There will be a whole long list of reasons, okay? Because he wants to protect himself. And then as a franchisee, you probably have very, very little rights or reasons to terminate the franchise agreement. As a franchisee, your right to terminate the franchise agreement is very limited in scope. And the purpose of this is to prevent franchisees from breaking the franchise agreement and escaping if the business doesn't work out. The last important clause that you should focus on is deposits. Quite frequently, franchise agreements require the franchisee to pay a deposit as a sign of commitment. This deposit can be quite huge, and it's important to understand the terms under which it might be forfeited. One common risk is the stipulation that the deposit will be forfeited if the franchisee fails to open the first store by a specified deadline. This clause is designed to ensure that franchisees are serious and committed to launching their franchise on time. Missing this deadline can result in a significant financial loss because the landlord will just eat up your deposit. It is essential to carefully review the timelines and plan your store opening meticulously, especially the opening of the first store. Factors such as finding a good location, obtaining all necessary permits, licenses, and approvals, and completing the construction of the store, the first store, can affect your ability to meet the deadline. Always ensure that you have a realistic timeline and always have a backup plan to avoid your deposit being forfeited. You don't want to be faced with a situation where construction delays or delays in getting a permit will cause you to miss the opening deadline for the first store, and this will give the franchisor the right to forfeit your deposit. Therefore, always do your due diligence on the proposed location of your first store. Think about the demographics, existing competitors, foot traffic, and the likelihood of being able to find customers in that location. You should ideally have a backup location for your first store because the franchisor always has the right to approve or reject a proposed location. So it is always wise to get in-principle approval from the landlord. You want it in writing before paying the deposit under the franchise agreement or under your tenancy agreement. Always seek legal advice to fully understand the terms and to protect your interests. You know, sometimes I don't know what's wrong with people, you know, they can spend a few $100,000 on the deposit to pay a franchise agreement, a few $100,000 to pay the deposit for a tenancy agreement, but they won't spend a single cent to get a lawyer to review the franchise agreement, to tell them about the red flags. Thanks for watching this video. If you find it useful, please like, share, and subscribe.